Back. You're watching Your World at 10 now. As we've been telling you, Vodafone has lost the case in the Bombay High Court against the Income Tax Department. The High Court says the IT department does have jurisdiction to tax the Hutch Vodafone deal. The judgment says that the transfer of the one solitary share of the Hutch Cayman Islands holding company reflects only part of the arrangement. The court found that the Hutch Vodafone deal price factored in diverse rights and entitlements, and as a result, the Hutch Vodafone transaction was in fact a composite transaction, not just that of one Cayman Island company share. The court held that the transfer of these rights and entitlements constitutes capital, which can be taxed as part of NRI income. However, the court has asked the assessing officer to apportion income resulted to HTIL, that's Hutch, between that which is a result of nexus within Indian tax jurisdiction and that which lies out. So there is a proportionality to this judgment as well. Vodafone now has 8 weeks to appeal before the Supreme Court. The IT department cannot pass any order for the next 8 weeks because the Bombay High Court has stayed its order for the next 8 weeks. Joining us to talk about the implications of this judgment, Nishith Desai of Nishith Desai Associates, a well-known tax lawyer in the country, and he's also been advisor to Vodafone on this case in the past. Mr. Desai, what do you make of this judgment and what it means for the principle of taxing offshore transactions in India?
The immediate takeaway for me is that all is not lost. I think when we heard the summary of the judgment in the afternoon, it appeared that case was lost.
Right.
But all is not lost. In fact, very interestingly, court has really tried to interpret the law as it is and indicated that when it's a case of a non-resident and he is taxable on his Indian source income, then he can be taxed only on that Indian source income and not on the foreign source income. But in a case like this, possibly there is a composite transaction of maybe transfer of shares outside India, and there are number of entitlements, including the control premium, use and rights to the Hutch brand and non-compete agreement and the value of non-voting and non-convertible preference shares and so on and so forth. So now, would this have source in India or not? Now, the court has said that if there is part of the source in India, part is outside, then only that portion that is cited in India can be taxed. Now, and it has gone on to say that it is not for this court to determine this issue at this point in time. So all that really speaking has happened is that the High Court has said the tax department has jurisdiction to proceed in this matter against Vodafone, but I would say all is not lost. That is my basic takeaway.
Well, that's fairly more optimistic than how you were sounding in the afternoon, Mr. Desai. This apportionment angle seems to be a twist in the tail because what we were expecting was quite simply a direction from the court on whether such offshore transactions are in fact taxable in India or not. They've managed to establish an India nexus on the basis of these contractual rights and entitlements that came along with the share transfer that in fact took place offshore. Now, how does one in the tax department or outside of it actually break up the deal value to be able to apportion what part of that value lies with the contractual rights and entitlements and what part of it lies with, let's say, the controlling interest which was transferred through shares which was transferred offshore? This is a difficult, complicated and potentially even more litigious exercise, right?
Yeah, absolutely. But I believe that, next game will be what is cited in India, what is taxable in India and what is not taxable, and how do you attribute values to some of these things which I talked about. It is going to be a very tricky issue, but that is what is the next ground on which we are going to play.
How do you expect this will impact other M&A transactions which reportedly also have been under scrutiny over the last 2 or 3 years? Similar such offshore transactions which in fact did have underlying assets in India. Because, this judgment, does it fit as a precedent for all transactions? Because this is a pretty unique structure of its own. So I'm wondering if this judgment would apply to all such transactions, considering that each one of those transactions would have different structures, may not have this degree of contractual rights or things like that.
Exactly. In a sense, if I may put it in other words, the judgment is not that bad. I think it is extremely well written. It clarifies principles of law. It also goes to the extent of saying that, whatever the law is, sometimes whether there is a chargeability or not, that is what you need to find out. If there is an issue of compliance, for example, whether non-residents should withhold tax from the payment to be made to another non-resident, it may cause inconvenience to the non-resident, but if that transaction is chargeable to tax in India, then simply because non-resident is put to some inconvenience cannot take away the fact that it cannot be taxed and it does not have a jurisdiction. The tax department doesn't have a jurisdiction. So to that extent, I would think that this is a judgment on the whole reads pretty good. Of course, it will have to be clarified to what extent the income is taxable and really not. It may happen nothing is taxable. It may happen part of it is taxable.
Nothing is taxable, Mr. Desai, is wishful thinking.
In the future, I believe the role of a lawyer is going to be very critical, if I may so say.
Well, we must credit Vodafone for keeping the lawyering and consulting community well in the money for the course of the last 2 years. And, maybe potentially for the next year as well, if they do appeal this to the Supreme Court. This whole debate over substance and form with regards to taxation,
how does
this unravel over the course of the next 2 years? There's quite the likelihood that Vodafone will appeal to the Supreme Court still stands, so we may not have heard the last word on this from the courts.
Right, two things I would say at this point in time. One, the court has very clearly said that there is nothing wrong in tax planning, there is nothing wrong in tax avoidance. Everyone is entitled to do his tax planning in a way that he can minimize his tax effect. I think that's a very important statement that has been reiterated in this judgment. Number two, that when the form prevails over the substance, that is an established rule now in India. But form is, if it is not something which you parties say it is a form, but really speaking it is something else, then the courts have right to go into the details and find out what exactly is the true nature of the transaction. And so to that extent, again, I will say silver lining. If you prepare your documentation, if you have your structures right, if you clarify a lot of these things which are being talked about in this particular agreement in the future, I think still one can legitimately avoid taxes. At the same time, what is due to India will be paid up, and you have to be reasonable at all point in life. So one will have to look at all these different documents. The biggest thing that often happens is that when some group of people would look at tax, some people will look at FIPB, somebody will look at SEC, some people will look at different things. If you take a whole picture and then decide as to how to go about doing a transaction, then you will be taxed on only the right amount and not on the wrong amount. So it is going to be very important. And whatever is due, I think companies should be willing to pay up. But rather than, keeping too many things ambiguous and giving department some kind of a leeway to, apportion what is taxable and what is not taxable.
You think Vodafone is kicking itself for not having done this transaction through Mauritius-based companies, in which case they would have gotten considerable treaty protection, though nowadays even treaty protection is up for question with the tax department?
Well, I think there are always questions up, ultimately the law, and I think this judgment is extremely well written, I would say, in many ways.
Let me rephrase that. Mr. Desai, if they had done this transaction through a Mauritius-based company on both ends, that is the buying and the selling end, there's a good likelihood that they would not be where they are today in terms of taxability, right?
Right, and all that I can see, really speaking, from this judgment is court has even gone to the extent in some way to say that how can, there must be objective test for interpretation. Otherwise, how can a citizen decide his behavior as to, so ambiguity in the law creates a lot more problem for the citizen, and therefore you have to make sure that, as much clarity as we can get. I think that would be something that...
I guess that ambiguity portion is being dealt with potentially in the direct tax code bill, where they've laid out very clearly, what kind of transactions they hope to tax when they're offshore. We'll leave it there. Thank you so much, Nishith Desai, for joining us with your views on the implications of this Vodafone judgment by the Bombay High Court. With that, it's time for a quick break on Your World at 10, but we're going to